All right, so we've got a case today that really makes you kind of rethink what we consider like seasonal work. We're going all the way to the Philippine Supreme Court with this one.
Yeah,
You know it's going to be good because you sent it in.
definitely.
It's all about a group of employees at a campsite who are in this like battle to be recognized as like regular employees, even though their work schedule is anything but regular.
Right. It really makes you think about all the little details of seasonal work, Like we tend to think of it as those classic examples, agriculture, tourism, anything tied to a specific time of year. But this one kind of pushes the boundaries of that definition, doesn't it?
Yeah, for sure.
Yeah.
So imagine this. We're talking Highlands Camp in Zambales,
Yeah.
run by this religious foundation.
Okay.
They mainly host religious groups, so naturally they have like crazy busy periods and then times when things are a bit, quieter.
Makes sense.
Now, the employees in this case had actually been working at Highlands Camp for 10 years, doing all sorts of jobs, cooking, cleaning, maintenance, you name it.
Wow, 10 years.
Yeah, a whole decade. But here's the catch. Their work schedule was all over the place. From January to June, they were full-time. Then July to September, they were on call.
Oh, interesting.
October brought them back full-time. And then November and December, back to on-call.
So like a roller coaster schedule.
Totally. And this back-and-forth schedule is like the heart of the whole fight. Highlands Camp is basically arguing that because their business has these ebbs and flows, these workers are seasonal employees, only hired for the super busy season, so to speak. They even claim these workers had to reapply every year.
So Highlands Camp is saying, hey, it's the religious groups who dictate when they want to camp. It's seasonal by nature.
Exactly. But of course, the employees see it totally differently. They're arguing that they're actually regular employees who got a raw deal, unfairly let go. Their point is that, yeah, activity might slow down sometimes, but Highlands Camp is open all year round. They still need workers to keep things running.
Right. And that's a key point, isn't it? The business is running all year, not just for a specific season.
Exactly. And that distinction, the fact that the business was up and running year-round, that ends up being a huge factor in how the Supreme Court sees this whole thing. But before we get to the big finale of the Supreme Court, let's rewind a bit. This case went through a whole legal odyssey, starting with the labor arbiter, the government official who tries to sort out labor disputes.
So kind of like the first hurdle in this legal marathon.
Right, exactly. So what happened at that first stage with the labor arbiter?
Well, the labor arbiter actually sided with the employees. They ruled that they were, in fact, regular employees and that they had been illegally dismissed.
Wow, so round one goes to the employees. That must have felt pretty good at the time. But I'm guessing this isn't where the story ends.
Oh, not even close. The case then goes up the ladder to the NLRC, the National Labor Relations Commission.
Okay, so it's like another level of the legal game.
Exactly. And they basically review appeals of these labor arbiter decisions. So they look at it again, and guess what? They uphold the original decision saying, yep, regular employees illegally dismissed. They even added holiday pay to what the workers were owed. So at this point, it seems like a pretty clear win for the employees, right?
Yeah, 2 for 2. You'd think Highlands Camp might just call it quits there, but I have a feeling they're not giving up that easily.
Oh, you know it. Highlands Camp isn't throwing in the towel. They appeal again, and this time the case lands in the Court of Appeals. And this is where things take a really wild turn.
Uh-oh, what happened?
Well, the Court of Appeals completely flips the script. They overturn both previous rulings and say, nope, these are seasonal employees. Highlands Camp is right.
Whoa, what a plot twist. So 2 courts say regular employees, and then bam, the Court of Appeals comes in and totally reverses everything.
Yeah, talk about keeping everyone on their toes.
No wonder this ended up at the Supreme Court, right? I mean, this case raises some really fundamental questions about how we define seasonal work, especially as businesses get more and more complex.
Absolutely. And that's where the case of Ariel Espina, Annalie Delejean, Daria Donor, Roald Donor et al., petitioners versus Highlands Camp Rawlings Foundation, Inc., and Javelin Pascal, respondents, Edwin Adona, Daryl Montevirgin, Ederlina Esteban et al., petitioners versus Highlands Camp Rawlings Foundation, Inc., and Javelin Pascal, respondents, GR number 220935 and 2118868, July 28, 2020 comes in. The Supreme Court has to step in and untangle this whole mess. Are these workers seasonal or regular? And their decision, well, let's just say it made a lot of people rethink Philippine labor law.
Okay, so we've got this legal battle going on, 2 courts siding with the employees, then boom, the Court of Appeals throws everyone a curveball. Everyone's got to be waiting with bated breath for the Supreme Court's decision, what they end up deciding.
So the Supreme Court really made a splash with this one. Their decision had a big impact on how we understand labor law in the Philippines. They sided with the workers, said they were regular employees.
Wow, so they completely overturned the Court of Appeals. That's a pretty bold move, isn't it? What was their reasoning? Why'd they go that route?
Basically, they said Highlands Camp's whole argument about seasonal work, it just didn't hold up. They were like, look, the campsite is open all year round. Just because some months are busier than others doesn't magically make everyone seasonal workers. Plus, they pointed out that Highlands Camp didn't even have proper employment contracts that spelled out the whole seasonal thing.
So even though the workers had some on-call periods, the fact that the campsite needed staff year-round, that played a big part in the Supreme Court's decision.
Absolutely, yeah. The Supreme Court made it crystal clear that employers can't just slap a seasonal label on workers to avoid giving them all the rights and benefits that come with being a regular employee. They basically drew a line in the sand saying, this is what qualifies as real seasonal work, and anything else that's just trying to game the system.
Okay, so what's the line? What makes it real seasonal work, according to the Supreme Court?
Well, they said it's not enough for the work itself to have, a seasonal aspect to it. The employees also have to be hired only for that specific season, like they're brought on for the harvest and then their job is done, that kind of thing. And to make matters even worse for Highlands Camp, the Supreme Court saw right through their little trick of making employees reapply every single year.
So that yearly reapplication thing, that was their way of getting around having to classify those workers as regular employees.
Exactly. They were trying to dodge those labor laws. But the Supreme Court was having none of it. They called it out as a blatant attempt to keep workers in this limbo, this uncertain state where they don't get the full protection of the law.
So it sounds like Highlands Camp was playing fast and loose with the rules, and the Supreme Court said, nope, not going to fly. It's a good reminder that those labor laws are there for a reason. They're meant to protect workers from exploitation.
Absolutely. This whole case highlights the importance of understanding your rights as an employee, no matter what industry you're in. You got to know what you're entitled to. This decision from the Supreme Court, it's a landmark case for labor rights in the Philippines. It sets a precedent, a guideline for how we view seasonal employment. It's a big win for workers who might have been misclassified in the past. And you know what I find really interesting?
What's that?
Is this rule could go even further. Like, could it have implications beyond just traditional seasonal work? Could it impact other types of employment?
Are you thinking about the gig economy? You know, all those on-call jobs that are becoming so common these days.
Exactly. The courts focus on the continuous nature of the business. Even if the workers' schedules are all over the place, that could have a huge impact on gig workers and folks in those on-call roles. It makes you think, doesn't it?
It does. Could this case be used to argue that even people with flexible or on-demand work, could they use this to fight for more stability, more benefits?
It's definitely a possibility. That whole idea that the business is running all the time, even if individual workers have irregular schedules, that's a powerful concept. We might start seeing this argument pop up more and more as the nature of work continues to shift.
And what about that reapplication thing? The court really shut that down, didn't they? It's like Highlands Camp was trying to hit a reset button every year on those employees' employment history.
Yeah, trying to erase their past work, pretend it didn't happen. But the court recognized that as a way to sidestep the law, keep workers vulnerable, they made it crystal clear that kind of tactic isn't going to fly.
It really highlights how crucial it is to have strong protections for workers, especially as things change so rapidly, Think about ride-sharing drivers, freelance writers. They might have busy streaks and then slow periods, but the platforms they work for, they're running all the time, just like Highlands Camp.
Right. And this case could be a game changer. It might spark a whole new debate about what employment even means these days. As flexible work becomes the norm, like, where's the line between seasonal and regular in that context?
That's the million-dollar question, isn't it?
Yeah.
This case definitely gives us some clues. It emphasizes that the work itself has to be inherently seasonal, and the employment has to be limited to just that season.
Like working at a ski resort that's only open in the winter versus, say, a restaurant that might be busier on weekends but needs staff all week. One's truly tied to a specific time of year. The other just has, some ups and downs in demand.
So it's not just about a business having busy seasons and slow seasons. It's about whether the work itself is fundamentally linked to a certain time of year, like harvesting crops, or, as you said, that ski resort example.
Exactly. And what the court's saying is having some slow periods, That's not a good enough reason to call someone seasonal and deny them all the benefits they deserve as a regular employee.
It's a subtle difference, but it's a super important one. Workers and employers both need to be aware of that distinction. And as things keep evolving, we've got to keep those definitions in mind.
Totally agree. This case brings that nuance to the forefront, makes us reevaluate our assumptions about seasonal work and how we make sure all workers are protected as the economy keeps changing.
It's kind of like a wake-up call, don't you think? This whole case. Like, hey, those labor laws are there for a reason. Employers can't just, try to find loopholes.
Yeah, it really drives home the point that you got to know your rights as a worker, no matter what. If you're just starting out or you've been working for years, understanding those legal protections is crucial.
Totally. It's about being empowered, right? Knowing your rights so you can actually stand up for yourself and make sure you're getting a fair shake.
Exactly. Knowledge is power, especially when it comes to the workplace.
So let's bring this back to you, dear listener. What does all this mean for you? Well, if you're in the Philippines, this is a big win. It sets a really important example for how we should be looking at seasonal employment. It's a reminder that you deserve fair treatment, you deserve protection, even if your work has those busy periods and then slower times. But here's a thought, something to chew on. Could this ruling go even further? Could it change how we view gig workers, people with on-call jobs? Could it reshape how we define employment as the world moves more and more towards flexible work? It's a big question, isn't it?
It really is. As the way we work keeps changing, we've got to keep pace with how we think about labor rights, how we make sure everyone's protected. This case could be the spark that gets those conversations going.
And that's a wrap on another deep dive. If you've got a case that needs some unpacking, hit that subscribe button and send it our way. We'll be back soon with another one. Until then, keep those legal gears turning.